So get this. Can you imagine getting sued by your neighbors over a single light bulb? It sounds totally absurd, right? But for one couple, this wasn't a hypothetical. It was their reality. Today, we're going to dive deep into a wild legal battle that literally started with a floodlight and ended up in a courtroom. And trust me, it reveals a ton about just how much power your homeowners association can actually have.
So that brings us to the big question, right? Can your HOA really take you to court over a light bulb? Well, this case shows us that the answer is a big fat yes. But it's the why and the how that makes the story so fascinating. That's where all the juicy details are. So let's rewind and start from the very beginning.
Okay, so our story kicks off in what sounds like a perfectly normal, quiet suburban community, right? It's called Circle G Ranches 4. But little did anyone know, one simple light fixture was about to become the spark that would ignite an absolute firestorm, pulling in neighbors, lawyers, and eventually even judges. All right, so let's meet the key players in this drama. First up, we have the homeowners, Darryl Jacobson-Barnes and Robert Barnes. Then, of course, you've got the HOA itself, the Circle G Ranches 4 Homeowners Association. But here's where things get, well, complicated. The person who filed the initial complaint, Michelle Mooney, wasn't just a neighbor. She was also a member of the HOA board. Now that right there, that's a dynamic that immediately makes you go, It just screams conflict of interest, doesn't it? And this is where it all started, this official violation notice sent on May 27, 2020. The language is pretty direct, no beating around the bush. The unapproved floodlight installed on the back of home needs to be removed. Please submit an architectural application. So they basically had two choices, get rid of the light or try to get approval after the fact. Yeah, this was not a friendly suggestion from a neighbor. This was a formal, official demand. So you might be sitting there thinking, wait a minute, what gives an HOA the power to do this? And the answer lies in these three little letters, CC&Rs. That stands for covenants, conditions, and restrictions. You can basically think of it as the constitution for your neighborhood. It's the official rule book. When you buy a house in a community like this, you're basically signing a contract saying you agree to follow all those rules. And that makes it totally 100% legally binding. And in this case, the HOA pointed to one specific rule in that big rule book, Article 3, Section 3.10. It says you need to get prior approval for any structure. And that one word, structure, that's the word this entire legal battle hinges on. It's crazy, right? Is a floodlight a structure? The fight to answer that one little question would end up costing everyone a whole lot of time and money. But the homeowners, they didn't just roll over and take down the light. Nope, they decided to push back. And that decision is what turned this whole thing from a simple violation notice into a full-blown conflict. It started climbing the ladder of escalation, moving from letters to the much more serious world of formal hearings. And man, things escalated fast that summer. Just look at the timeline. The notice goes out in late May. By early July, boom, they're in their first hearing where they actually agree to try and work it out themselves. But that doesn't work. The resolution fails. So just 2 weeks later, they're back for a second hearing. And then, in mid-August, the final hammer comes down. The HOA board officially denies their appeal. We're talking less than 3 months from the first letter to the door for any kind of friendly solution getting slammed shut. Wow. Now, here's a little detail about that final meeting that might seem small, but trust me, it becomes incredibly important later on. The board held their discussion about the appeal out in the open, in an open session for everyone to hear. But when it came time for the actual vote, they went into a closed executive session behind closed doors. And as you can probably guess, the homeowners seized on this, arguing it was a violation of open meeting laws. This became a huge piece of their legal strategy. So, with the HOA giving them a final official no, the homeowners had basically hit a brick wall. They'd exhausted all their options within the community system. Their only move left? Go over the HOA's head and take this whole fight to the state by filing a formal petition in court. Okay, so their lawsuit basically boiled down to 4 key claims. Let's break them down. First, they argued improper notice, saying the HOA didn't follow the right steps in their communication. Second, improper procedure. That's the whole closed-door vote thing we just talked about. Third, they claimed the penalty was unenforceable, arguing the fine itself was actually illegal under state law. And finally, they went back to the very beginning, the core issue, outside of scope. They argued that a floodlight simply isn't a structure, so the whole rule shouldn't even apply in the first place. So, the case is now officially out of the HOA's hands. It lands on the desk of an administrative law judge. Now, this is a judge who specializes in these kinds of disputes, dealing with specific rules and regulations. It was up to this judge to go through each of those 4 claims one by one and finally decide who was right. All right, first up, the improper notice claim. The judge looked at the evidence and sided with the HOA. The ruling was that the original notice sent way back in May had all the legally required information in it. So right out of the gate, boom, the homeowner's first big argument is shot down. The judge basically said the HOA followed the procedure perfectly. Okay, next up was that improper procedure claim, the closed-door vote. Now, on the surface, this seemed like a really strong argument for the homeowners, right? But the judge pointed to a very specific loophole in the law. It turns out HOA boards are allowed to go into a closed session if they're seeking legal advice from their lawyer. And since that's exactly what the HOA claimed they were doing, they hadn't actually broken the law. So there goes claim number 2, dismissed. So the judge moves on to the last 2 claims. The argument about the unenforceable penalty, that got tossed out on a technicality. It turns out the homeowner's lawyers cited the wrong state law. Ouch. And then the big one, the question this all started with. Is a floodlight a structure? The judge's answer was clear. Yes. In the context of the CC&Rs, an unapproved floodlight is absolutely considered a structure, and it falls squarely within the HOA's power to regulate. And just like that, it was over. The judge ruled against the homeowners on every single one of their 4 claims. The final verdict couldn't have been clearer. Petition dismissed. After all that, the HOA had won. Case closed. So, after all the time, the stress, the lawyers, the hearings, what are we supposed to take away from this? Well, this whole story is really a powerful and maybe a little scary cautionary tale for anyone who lives in a neighborhood with an HOA. There are really 3 huge lessons here. First, and this is the big one, you have got to read your CC&Rs. Seriously. The homeowners lost this case because the judge agreed that a floodlight counted as a structure based on that document. If they'd known that from the start, this whole mess could have been avoided. Second, document everything. I mean everything. The entire case for both sides was built on that paper trail of letters and notices. Your best protection is always a good record. And finally, number 3, understand the process. The HOA won here not because they were necessarily right in some grand moral sense, but because they followed the legal procedure to a T. In these kinds of fights, the process, the procedure, it's absolutely everything. And all of this leaves us with one last big question to think about. I mean, in this fight over a single floodlight, the HOA won because it followed the rules perfectly. But when things escalate to the point where neighbors are suing each other, does the community really win? Or is the only true winner in the end the process itself?